What is good, everybody? It's your boy, Corey from the Hardwood Herald, and today I want to talk about amateurism in the NCAA. It's a hot topic based on, the new bill that was signed in California that is going to potentially allow athletes to make money off their likeness. So let's start out by defining amateurism, right? The NCAA defines amateurism as the bedrock principle of the sports. They say that it's the practice of engaging in sports for pleasure rather than for financial benefit or professional reasons. The NCAA believes that amateurism is crucial in providing an environment in which academics and acquiring a proper education is the first priority in a student-athlete's life. Well, over the years, the world has seen a big debate about whether college athletics truly are amateur sports. The evolution of how we consume sports has left us in a perpetual gray area that's muddied the lines between amateur and professional. Now, due to the case Law versus the NCAA, which found it illegal to limit the compensation of a coach, NCAA coaches are no longer capped on their earnings and are now making millions and millions of dollars a year. Michigan Wolverines head coach Jim Harbaugh is making over $9 million annually, while John Calipari at Kentucky is earning over $7.5 million in salary annually. So if the coaches are being paid as professionals, why aren't the players? So the NCAA may have started out in a completely amateur capacity. However, the NCAA now benefits from licensing agreements, merch sales, and broadcasting deals that generates nearly $1 billion a year. In 2016, the NCAA made $996 million in revenue, and none of that revenue went to the players, who most people feel are responsible for generating the money. Now, studies have shown that college athletes themselves view themselves as athletes and not students. In Division I football, 59% of student athletes claimed that they attended their university because of athletics and not academics. This number jumped up to 68% for men's basketball and 79% for men's baseball. 72% of male athletes in the remaining sports considered themselves athletes first, as did 64% of women in college athletics. Now, nearly every athlete dreams of playing professionally one day. We all did, right? And some of those athletes will one day get that opportunity. The ones who do, they view college as a means to an end. These athletes view college not as an opportunity to further their education, but as a way to end up in their respective professional sports leagues. So let's look at some cases like OBannon versus the NCAA, Berger versus the NCAA, White versus the NCAA, and we'll look to see how labor acts and antitrust acts fit into this topic. We'll look at how we got to these cases, the court's decisions, and how these cases have impacted the concept of paying college athletes in the future. So let's talk about the Sherman Antitrust Act and the NCAA. The Sherman Antitrust Act is a federal statute passed by Congress in 1890. The intent of the Sherman Antitrust Act is to protect the public from the failure of the market. In other words, the law aims to prevent conduct that unfairly destroys competition in the market. A lack of competition in a given market leads to higher prices and fewer choices for consumers, harming both the individual consumer and the market. Now, the first encounter that the NCAA had with the Antitrust Acts was through the case NCAA versus Board of Regents of the University of Oklahoma. Now, in this case, the Supreme Court held that the NCAA television deal violated the Sherman Antitrust Act. The case dealt with college football television rights and how the NCAA controlled those rights. The NCAA felt that nobody would go to the games if they could watch them on television. They believed that they were protecting their live audience by limiting the amount of television broadcasts for each school. The NCAA had been negotiating a television deal with ABC and CBS when a number of schools formed the College Football Association and began negotiating their own TV deals with NBC. Now, when the NCAA found out about these negotiations, they threatened sanctions against any school that participated. The University of Oklahoma is one of the schools in the CFA, and they filed suit against the NCAA to prevent them from taking action against any CFA members. The courts ruled that the NCAA violated antitrust laws under rule of reason and per se rules. Judge Bursigia issued a permanent injunction of the NCAA which prohibited them from interfering on individual university television contracts, as well as declaring the NCAA and ABC contract null and void. This case proved for the first time that an action of the NCAA could be an unreasonable restraint of trade. Now, one of the major impacts that the NCAA versus Board of Regents case had was that it unintentionally laid the groundwork for what the courts would label as amateurism in future cases. The case explained how amateurism serves as the major pre-competitive justification for mutual agreements between the NCAA and its member schools to restrain trade because it preserves college athletics as a distinct product. When cases like McCormack versus the NCAA challenged amateurism, the courts quickly looked at the Regents case to rule in favor of the NCAA. Now, the most popular recent challenging of amateurism in the NCAA is probably OBannon versus the NCAA. Ed OBannon was a college basketball player who attended and played for the UCLA Bruins from 91 to 95. OBannon testified that while watching his son and his son's friend play a video game from EA Sports in 2008, he noticed the game was using his likeness from the UCLA 95 championship team. This likeness, OBannon had not given permission to use, and he had not been compensated for the use of his likeness. OBannon then filed a class action lawsuit against the NCAA, challenging the use of former student athletes' likeness for commercial purposes. The U.S. District Court for the Northern District of California ruled that the NCAA rules that prevent college basketball and football players from controlling the commercial rights to their names and likeness unreasonably restrains trade in the market for certain educational and athletic opportunities offered by Division I schools. The court then issued an injunction preventing the NCAA from restraining its members from compensating their men's football and basketball players up to $5,000 a year for the use of their likeness. The court then stopped the NCAA from prohibiting monetary awards to college athletes in the amounts up to the full cost of attendance of the athletes' respective schools. The full cost of attendance is estimated to be from $2,000 to $5,000 more than the value of attendance at a university. The decision to pay athletes the full cost of attendance in the OBannon case is an issue that piggybacked off of another suit against the NCAA. In White versus the NCAA, a proposed class action suit filed in 2006, 4 former college athletes led by the former Stanford University football player Jason White sued the NCAA for placing a cap on the financial aid a student athlete could get in the form of an athletic scholarship. The plaintiffs in the suit alleged that the NCAA was in violation of the Sherman Antitrust Act, which prohibits illegal restraints of trade, by precluding college from offering athletic scholarships up to the full cost of attendance. Scholarships included tuition, room, board, and textbooks, but failed to account for laundry, school supplies, phone bills, travel expenses. The plaintiffs argued that the schools were denying the athletes the benefit of competition, and because of their participation as a student athlete, they were at a disadvantage in having the time and opportunity to acquire part-time jobs to earn the money that other students may earn. The NCAA knew that a loss in this case would be extremely costly, so they settled for $18.9 million. Now, the OBannon decision is a step forward for college athletes because it recognizes that NCAA rules prohibiting college athletes' pay may violate the Sherman Antitrust Act by restricting trade. Although the OBannon decision is a promising start for college athletes receiving a form of compensation, it's not been extended to every college athlete. Jillian Berger and Taylor Hennig attended the University of Pennsylvania and were members of the women's track and field team. Now, in Berger versus the NCAA, Berger and Hennig brought suit against the NCAA, the University of Pennsylvania, and 120 other Division I schools, claiming that student athletes are employees under the Fair Labor and Standards Act. The FLSA requires that every employer has to pay their employee a minimum wage of $7.25 per hour. Section 203E(1) of the FLSA defines an employee simply as any individual employed by an employer. In order to qualify as an employee for purposes of the FLSA, one must work for an employer. Berger and Hennig believe that the NCAA and its member schools were in violation of the Fair Labor and Standards Act by not paying their athletes a minimum wage. The district court ruled in favor of the NCAA and its member schools. The court reasoned that Berger and Hennig were amateur student athletes and not employees of the school. Furthermore, the court reasoned that because track and field is not a revenue-generating sport for the school, that the NCAA's motion to dismiss the case should be granted. The court went further to state that if Berger and Hennig were to be considered employees for participating in a non-revenue-generating sport like track and field, then so too should journalists, musicians, actors, and debaters enrolled at the school. The court did, however, believe that if the plaintiffs in the case were members of a revenue-generating sport, their claim would be more reasonable. Now, more recently, in 2012, Johnny Manziel became the first freshman to win the Heisman Trophy. Manziel immediately became one of the most exciting and polarizing players in college football history. Due to his growing popularity, Manziel and Texas A&M encountered a big problem. The problem was a slew of unlicensed merchandise boasting Manziel's nickname of Johnny Football. Manziel and the university had to send out a number of cease and desist letters to stop the production of the bootleg merch. At the surprising recommendation of Texas A&M, Manziel was allowed to register a trademark for the nickname Johnny Football. The university worked with Manziel and his family to get the trademark done as a way to prevent Manziel from encountering any issues with his NCAA eligibility. As the trademark process was underway, a bootlegger named Eric Vaughn persisted in selling Johnny Football merch. J-Man 2, the LLC that the Manziel family registered for the use of the Johnny Football brand, filed a lawsuit against Vaughn for trademark infringement. In 2013, J-Man 2 also filed a similar suit against Kevin Doolin, who ran a company called Cubby Tees that was also selling Johnny Football merch. Manziel settled both cases, and the NCAA ruled that Manziel could keep any financial earnings from the lawsuits without losing his status as an amateur athlete. This decision by the NCAA was highly controversial as it led to accusations that a loophole may have been created for athletes to receive compensation. It was argued that this loophole made it so that boosters of a university can now infringe on an athlete's trademarks, be sued, and pay the student-athlete in legal damages. The NCAA quickly came out and claimed that any such orchestrated event would be deemed a violation. The NCAA then ruled that if Manziel's trademarks were accepted, that neither Manziel nor Texas A&M could profit off the Johnny Football name until Manziel was no longer a college athlete. Manziel was no stranger to controversy. In 2013, Manziel was suspended for the first half of a game for signing a stack of autographs. With a lack of evidence, Manziel was suspended on the basis that he received a large sum of money in exchange for his autograph. The NCAA claimed that even if Manziel didn't receive payment, that he should have known that the autographs would be sold for profit. This led to what many claimed was an absurd view from the NCAA that athletes must also abstain from other people profiting off of their name. Some argued that the NCAA took this stance due to their other current cases, OBannon and Keller, that questioned if Division I college football and basketball truly are amateur sports. While the OBannon case and the Manziel cases both deal with licensing, the difference between Manziel's trademark case and OBannon's case is that a trademark for Manziel would be unique to himself specifically, while OBannon's case involves a situation involving the entire team. In the OBannon case, the characters in the video games rely wholly on the bond between the schools and the players. But in Manziel's case, the trademark can exist outside of just NCAA football. So when asking the question, should college athletes be compensated, you have to look at the current state of NCAA Division I sports and ask if what you're watching is truly an amateur sport. If the NCAA is no longer an amateur sport, then the NCAA would be in violation of the Sherman Antitrust Act. When watching Division I basketball and football, I can't believe that I'm watching an amateur sport. The top college athletes attend college for their sport, not the academic programs that the university offers. In Division I basketball, the process of one and done is what the majority of players strive for. One and done is when a player leaves their school after only 1 year to pursue their professional career. While the NCAA may have started as an amateur sport league, they no longer should be considered amateur. The NCAA continues to take advantage of their student athletes. If you go to the NCAA March Madness YouTube page, you'll find video upon video of individual player highlights. These highlights are generating thousands of views and generating online ad revenue off of the back of the player who receives nothing. The NCAA is a billion-dollar business, and it continues to allow their athletes to struggle financially as the NCAA and its member schools continue to line their pockets. I also believe that the current system the NCAA thrives in is discriminatory. Amateurism may not have intended for this problem to occur, but through adverse impact, the process in which facially neutral rules have an unjustified adverse impact on a particular group, the process has become discriminatory against African Americans. Robert and Amy McCormick wrote a law journal titled Major College Sports, A Modern Apartheid, arguing that major college sports programs hold racial minorities in legal servitude for the profit and entertainment of the racial majority. In a league that's predominantly made up of African American athletes, mostly European American men are the group who gets to bask in the profits. In the case of Johnny Football, I believe that Manziel should have been allowed to receive compensation for his autograph and any merchandise based off of his trademark. A musician or a journalist who attends the university can profit off their name and talents, but a student athlete can't? I don't see how that equivalency is fair. A popular solution that's been discussed is to allow college athletes to acquire sponsorships through the Olympic model. The Olympic model allows for athletes to sign endorsement deals with companies who in turn pay the athlete for their fame and marketability. This seems like a fair solution that allows the NCAA to remain amateur, yet the athlete could still make the money they're worth through endorsements outside the NCAA. Still, in 2017, the NCAA is fighting to maintain that amateurism is the foundation of college sports. Still to this day, almost in 2020, they're fighting to maintain that amateurism is the foundation of college sports. The NCAA claims they're of the belief that amateurism allows their players to play for the love of the sport and not for financial benefit. We're too aware today to see this falsehood. We know that education is not the NCAA player's top priority. Every player has their dream of being a pro, and playing for an NCAA-sanctioned school only is a means to an end. Although cases like OBannon has shown a dim light at the end of the tunnel in the fight for fair pay for college athletes, there's still a long, long way to go. The case NCAA versus Board of Regents has made it easy on the NCAA to preserve their concept of amateurism in court. I do believe in the future there will be too much evidence to rely on this outdated ruling, and the bill passed in California is definitely a great step. Division I NCAA basketball and football, it's big business. It competes with the professional leagues for airtime and ratings, and it creates enormous amounts of revenue through their television contracts, licensing deals, merchandising sales. The list goes on. Student athletes must keep up their fight to get compensated for what they deserve, for pushing the NCAA brand further and further every year.